Good evening, everyone, and thank you so much for joining us this evening. You are here, if you are here for school discipline and code of conduct and student rights for students with disabilities, you are in the right place. Even if you didn't come for that, I suggest you stick around because this is going to be a really interesting topic. Um, so for those of you who are not familiar with the task force, we are the regional arm of New York State Special Education Task Force, which is run under the umbrella of the Disability Rights New York. This task force seeks to bring together the full spectrum of stakeholders in special education in forums such as this one to exchange ideas and promote positive outcomes for students with disabilities. I'm Debbie Goddard, and I'm currently the Executive Committee Chair, along with my co-chair, Jennifer Lamont, who I think is here in the audience. I want to thank the Task Force Executive Council members who were able to join tonight. Alyssa, who is here, and she'll be managing the Zoom. I saw Julie, Jessica, Stephanie, who will be wearing double hats, both as a member of the task force and one of our presenters this evening. And Mary Ellen, welcome and thank you for joining us. So the federal and state law provides protections for students with disabilities as it relates to student discipline. This presentation will address proactive steps to address conduct before it leads to discipline. There will also be a conversation on the procedural safeguards required when an out-of-school suspension is imposed by a school district. The presenters will emphasize the importance of alternatives and how that can be accomplished given the law. We are honored to be joined by Stephanie Roebuck, who is a principal at Keene and Bean Law Firm, and Stephanie Shaman, the legal director of student advocacy. So I will turn it over to you, ladies. Thank you so much for spending the evening with us.
So good evening. I'm just going to share my screen right now. Okay. I think it should have worked. There we go. So can you all see the screen?
Yes, Stephanie William.
Terrific. So good evening, everybody. My name is Stephanie Shabman. I am the legal director at Student Advocacy, and I am delighted to talk on the topic of students with disabilities and school discipline. At Student Advocacy, we handle a lot of these matters, and I was honored to be asked to speak on the topic by Stephanie Roebuck, who will also speak after me, and we'll kind of toss it back and forth and comment in between. We would be happy to answer questions, not individual questions, but questions at the end of the presentation. And we look forward to trying to work together. So here we go. Next slide. Okay. This is the cautionary note that in the event you need legal advice, this presentation is not legal advice to anybody in particular, and we recommend that you consult an educated attorney. Okay, next slide. Agenda. So we're going to go through the codes of conduct, types of school discipline, suspension of all students, and then some of the special protections for students with disabilities, and alternatives to suspension and restorative practices. Okay. I could not speak at anything without giving the mission of student advocacy. Student advocacy protects and advances students' legal educational rights to ensure equal access to school resources and opportunities. We are the only nonprofit in our region whose exclusive purpose is to provide counsel and legal representation on educational matters at no cost to families with limited financial resources. So that's enough about student advocacy. We're going to jump right in to what you've all come to hear, and that's about the discipline. Okay, whoops, I'm going to go back up. I can't. Oh, sorry, I'm jumping ahead of myself. Okay, you start at the code of conduct. The code of conduct is required to be distributed every year to all students in the school now with computers, it's posted every year, and it's a really important document for you to review with your students, with your families, with your clients, wherever hat you are wearing, because it establishes the rights and responsibilities of all members of a school community. It promotes, or the goal of it is to promote a safe, healthy, orderly, and civil community. It encourages academic, social, and emotional development of all students so that the school environment should be conducive to learning. Codes of conduct include appropriate and acceptable behavior on school grounds and at school events, standards to ensure security of students and school personnel, disciplinary means, conduct that is prohibited, and a process and procedure when the code is violated. So now I'm just going to get into a little bit of the disciplinary sanctions, because people think about, oh, the long-term out-of-school suspension, but there are many levels of disciplinary sanctions that can be imposed upon a student, and it's all laid out in the Code of Conduct. So if you have a question, the first place you start is the Code of Conduct. It goes all the ways from an oral warning, a written warning, all the ways to a short-term suspension and a long-term suspension. And there's many in between. So if your student is faced with a violation of the Code of Conduct, student advocacy, and this is a big proponent of trying to settle the matter collaboratively. And I've worked with Ms. Roebuck on, I don't know how many hundreds of school cases where that was the case. And it's called a stipulation for those people who are not lawyers. A stipulation is a written agreement between the school district and the family. And it's an agreement, it's a contract, and it's used to resolve disciplinary matters without having to go to the hearing. So you have to give up something in order for a stipulation to be effective, and the other side has to give something. But it's advantageous because it avoids the hearings and appeals process. And if you've ever had the unfortunate circumstance to be at a superintendent's hearing, it's a pretty intense hearing. It's an administrative hearing. There's rules of evidence, and it's very often very upsetting to the student and the family. So if there's an opportunity to resolve it amicably, that's the very heart of working collaboratively with your school district and also joining other community partners as part of that. It's good to have a stipulation because it provides clarity and certainty for both parties. And it can include many conditions that are not a proper penalty if the student is found guilty of the allegations that could not ever possibly be the result of a disciplinary hearing. And Stephanie Roebuck is going to go into details about what that will look like, but that is you have a sense of control over the outcome. Both parties do. So a little bit more about what a stipulation is. There's an admission or acknowledgement of a code violation. There's an agreed upon disciplinary consequences, and it's a very vast range of things. There's usually a condition for reinstatement for when the student is eligible to return to school, and there's waiver of certain rights. The parents should review, and this is an advocacy tip, very carefully before signing. The stipulation is signed by the parent, the student, and the superintendent of schools. So because there are a lot of qualifiers in there, we strongly recommend that these stipulations be reviewed by an attorney who understands this very nuanced area of law. Okay. There's something else that a lot of parents, schools are faced with, and a lot of teachers and a lot of other professionals, and it's called an informal school removal or an unofficial suspension. So you might wonder what that is. A student is sent home early without a formal suspension letter. You might have heard it referred to as a soft suspension or a mental health day. And sometimes parents or teachers or school administrators feel like they're doing the student a favor by doing that. There's no disciplinary record, there's no, it's not adversarial, but we strongly recommend that parents do not pick up their child from school unless the nurse calls them and they're sick, or unless there is an official suspension. And the reason we'd say that is because it bypasses the due process protection. So a really well-meaning school person might say to the parent, come pick him up. He's not doing so great today, and it's not. But what they don't realize, and they do it with the best of intentions, and the parent wants to work cooperatively with the teacher. But what happens is they're bypassing the protections that are put in by the statute. It can often lead to missed instruction, and obviously there's lack of documentation because there's no letter. So what should a parent do? They know their kid's struggling behaviorally in school. So here, this is the advocacy tip. These are the proactive things that families can do. Request a team meeting or a program review. Bring all of the stakeholders together and talk about what needs to be changed or what needs to be added to an IEP so that this child is able to access education. Ask for a functional behavior assessment and whatever supports would come out of that. And ensure that all removals are documented in writing. Now, I am going to just say that there are, of course, official school suspensions, which is my next slide, but I am going to turn it over to Stephanie so that she can get into all the regulatory requirements. Thank you so much. I think I have to stop sharing and then you can pass it
You
back
do
to me.
need to stop sharing and then I'll share mine. So,
Thank you.
okay.
Thank you. There we go.
Okay. Can you see that?
Perfect.
Okay. So thank you, Stephanie. And I think Stephanie brings up a lot of, really invaluable tips for parents who are trying to navigate this process because um, generally most of the parents that I encounter as an attorney for a school district, this is their first time through this process. And the formality and the seriousness of it is, daunting and overwhelming. Unfortunately, this is an area that is highly regulated. The regulations of the Commissioner of Education, the provisions of the education law for New York State, the provisions of the education law as it relates to students with disability on both the federal and the state level, and even there's Supreme Court decisions that really relate to how you can go about disciplining a student because in public schools, because the right to an education is considered to be a fundamental constitutional right. And when you take a fundamental constitutional right away from a citizen of the United States, at least right now, you're supposed to have due process hearings provided or some form of minimal due process provided to you before that right is taken away. So in New York State, there are a lot of hoops that need to be jumped through before we can suspend a student or take away their right to an education even in the short term. And that's why a lot of times those letters that you get if your child is facing suspension seem very there's a lot of legalese in them. They feel like they're very cold, but that's because lawyers have written them because we want our districts to comply with all the regulations and the laws that they need to, and not necessarily, act in a way that would, as Stephanie said, maybe well-meaning, trying to be more collaborative, but by doing so, take away certain rights that that the student and the parents have. So I'm going to talk a little bit about those statutory regulatory provisions, so that you understand when we get to the back end of this presentation, and we talk about maybe there are different ways we can approach student discipline and some of the more collaborative approaches you can take. You'll understand why some of those options are either limited or really require some creativity on the part of the parties, or more importantly, maybe some advocacy work on all of our behalfs to the legislature to change some of these laws. So the procedural requirements for student discipline are found under the New York State education law and the commissioner's regulations. There is a right to minimal due process to take away education for a student for 5 days or less. Those principal suspensions that are for less than 6 days. And there are more meaningful due process that is required to be provided if it's going to be a longer term suspension, which is defined as 5 days or more than 5 days, I should say. There are also enhanced due process protections for students with disabilities. Okay.
Stephanie, you're not in presenter mode.
Oh, I'm sorry. Let me
That's
try to
okay.
get to presenter mode here. Am I in presenter mode now?
No.
Okay. Yep. So want to get back to where I was though. Okay. 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 Oh.
Slide 2.
Yeah, I'm okay, so the authority to impose a suspension for 5 days or less is with the principal of the school or the superintendent of school. So if you receive a letter that is from an assistant principal or a dean of students, that is actually not a valid suspension letter, and you should bring that letter to the attention of the principal so that it can be the discipline can be properly authorized. The letter should have the notice that the parent and the student have a right to an informal conference to speak to the principal prior to the suspension starting. It is a right that you have that should occur, as I said, before the suspension starts, and it needs to be in that letter that is provided to you for these before the suspension starts. It should not be the meeting that you have when you come to pick up your child and the suspension letter may be handed to you when you come to pick up your child. That would not meet the requirements of an informal conference under the statute. The complaining witness under the statute is typically the staff member to whom the student admitted committing the alleged misconduct, if there was an admission, or a person who saw the conduct and reported it to the administration. And typically that's going to be a staff member. As I said, the timing of the written notice and the opportunity for an informal conference needs to take place before the suspension starts, unless the student is deemed to be a continuing danger to persons or property or an ongoing threat or disruption. So if you have a student who is alleged to have vaped in a bathroom, and there's going to be a suspension because this is the fifth time that they've been caught vaping in the bathroom, that really should not be an immediate suspension. There should be the opportunity for the informal conference prior to the suspension. However, if there was a major fight that was caused, a student calls in a bomb threat, something of a more, egregious nature where the child's presence the next day is going to cause a disruption, that could result in the suspension starting with the opportunity to have that informal conference the next day. You need to, as a parent, request that informal conference, and it needs to be held in your dominant language. And it allows for you and your child to tell the principal what happened outside of that contemporaneous time when an investigation is going on. Usually, something happens, there's an investigation, your child may be questioned, they may admit to something or may, say something that's not necessarily complete. The suspension then is, issued. This informal conference gives the student and the parent time to talk to each other and then how best to present their side of what occurred to the principal so that the principal can determine whether or not to uphold their own suspension or potentially change their mind when it comes to the penalty. Assuming that there is more serious conduct that the child has been accused of that may result that the district is anticipating would require a suspension of more than 5 days, that needs to be done by the superintendent of schools after what's called a superintendent's hearing, a 3214 hearing. Both the school district's code of conduct should say, and the education law definitely says, that only the superintendent has the authority to suspend a student in excess of 5 days. Typically, that short-term suspension will occur, that 5 days or less, with a referral to the superintendent's hearing. And after the hearing, if there is a determination of guilt, there would be a longer-term suspension imposed. No student may be suspended in excess of 5 days without this opportunity for a fair hearing upon reasonable notice. It is really important that you read those superintendent hearing letters that have the notice of the charges carefully. That charge that's in that letter is what the district needs to prove at the hearing and what you are going to need to address to defend your child. It makes sense to, if you're concerned about a long-term suspension, makes sense to try and consult with someone like Stephanie or other, of her colleagues across the region who represent students and families in these types of hearings. They are, as Stephanie said, administrative proceeding. The strict rules of evidence don't apply, but there still are recordings kept. Students will be asked to plead guilty or not guilty. There will be testimony taken under oath, and it can be very intimidating for everyone. So it would make a lot of sense if you're going through this process to try and reach out to an attorney if you're able to. That letter scheduling the hearing should be done, giving you a reasonable notice to attend. 1 day is not considered reasonable notice, but you have to understand the school district has to do this hearing within that initial 5-day suspension period. So there's not a lot of time in which that suspension hearing is going to occur. The superintendent's hearing is going to occur. So typically those letters go out, and within 2 or 3 days after receipt of the letter, the hearing will occur. as I said, the charge needs to be in that superintendent letter that you will receive. Um, your student, your child is entitled to alternative instruction from the day they are suspended through the day they return after the suspension. There is, the commissioner has recognized that it's sometimes difficult on a 1 day suspension to get the alternative instruction set up in time to do a 1 day suspension. The school district's obligation in that step is to take immediate steps to provide alternative education. But certainly for a longer term suspension, there needs to be either a tutoring setup, some sort of access to an alternative program like Putnam Northern Westchester BOCES has a program called Back on Track where they do education for students who are on suspension. That does need to be put in place for your child so they don't lose their ability to be educated during the time of their out of school suspension. And there has been a recent increase in the number of hours school districts are required to provide education on a daily basis. Right now, the minimum number of hours for elementary students was increased from 5 hours to 10 hours per week. And for secondary students, it was increased from 10 hours to 15 hours per week. Stephanie, do you want me to go on to discipline of students with disabilities at this point?
Sure, that would be great if you're comfortable with that.
Yeah,
Thank you.
absolutely. So the hearing would occur if we're dealing with a student who's not classified. The hearing would occur, hearing officer would determine whether or not the child's guilty or not based upon evidence presented at the hearing. The district does have the burden of proof. And certainly, the parents have the right to question any of the district's witnesses. They have the right to call their own witnesses as just a practical hint. If you as a parent want to call witnesses on your behalf, you should let the superintendent or whoever is holding the hearing or the district clerk who contacts you that there are people in the district you would like to call. Because let's say you want to call a teacher your child told you saw the fight that it wasn't testifying. It may be very difficult for us to, for the school district to find that teacher in the middle of the hearing if there was an advance notice that they needed to be on call. Certainly, if you want another student to testify on your child's behalf, that is something that you would probably need to arrange on your own, and or get an attorney to issue a subpoena for that child, because a school district would not make a student testify in a hearing like this without consultation with the parent of that child and getting their express permission. So to the extent that you would like that to occur, you're going to need to arrange for that to occur before you come into the hearing. Once if the student is found not guilty, they immediately go back to school. If they are found guilty, there would be what's called the penalty phase, where the student's disciplinary history would be reviewed, his or her attendance record would be reviewed. You could bring evidence of good conduct. I've been at hearings where parents have brought priests or rabbis or community leaders to come and testify on the child's behalf. And all that information will be taken into account when the superintendent determines what the penalty will be. So that's what we're dealing with when we're dealing with neurotypical kids. Now, when we're dealing with students who have disabilities, the law does provide for additional enhancements of protections because the law does not want students to be penalized for conduct they can't help. I mean, if their disability is the reason for the conduct, then there should be no punitive penalty provided to the student for that conduct. At least that's the theory behind all of this. So let's just talk about who gets this protection. So students who are disabled do have additional protection. And the way in which the law has sort of uh, developed in this area, clearly students who have IEPs, who have been classified by CSEs, are entitled to the protections under the Individual with Disabilities Education Act and the Education Law, Article 89, which are the statutes that deal with classified students. Students who have 504 accommodations and have a 504 plans may be entitled to these enhanced protections also, dependent upon their disability. So if your student has a 504 plan because they are impulsive and they've got ADHD and they have a 504 plan that is, set up to deal with some of the to accommodate that disability, and then they're accused of something like, yelling out a curse word at a teacher. Well, they're entitled to that disability. They're entitled to those protections because their disability potentially could have been a manifestation, or their conduct potentially could have been a manifestation of their disability. On the other hand, if your child has a 504 plan because they have a motoric disability, so they have a 504 plan because they're in a wheelchair. Their accommodation plan deals with access to elevators and things along those lines, and then they're accused of cheating, or something like that. It's likely they would not get the benefit of these protections because their disability, and the conduct are not connected. But for the most part, the advice that I give clients is if there's a 504 plan in place, you should probably consider the fact that there are enhanced protections in play here. There are situations where the law has developed in such a way where sometimes students who are going through the referral process may be considered disabled for these types of protections. So if there was a student whose parent or school has made a referral to the Committee on Special Education and they're in the process of doing evaluations, when the child gets in trouble, that child's entitled to the protections of the IDEA in terms of enhanced protection. If a parent has expressed concern in writing to a supervisor or administrative personnel prior to the conduct, or if a teacher has expressed to the specific concerns directly to the director of special education or some other supervisory personnel, even if there hasn't been a referral yet, it's likely those students would have the protection. What is not protected is child gets in trouble, and then after the child gets in trouble, there is a referral to the Committee on Special Education by the parents. That is not considered to be, the child is not considered to be one that would likely have the protections of the IDEA, because the law has basically developed that they do not want the referral process to be used as a shield for disciplinary purposes. If the parent has not allowed an evaluation or refused services, also the child would not be considered to be a child in need of protection. So if the Committee on Special Education has been requesting your child to be evaluated, or if your child has a classification, the school district is recommending, a special class program, you don't want the special class program, so haven't consented to special education services at all. By not consenting to those special education services, you have taken away those protections for your child for these disciplinary procedures. Okay, so Generally speaking, a child who is disabled cannot be suspended for more than 10 days. And that's 10 days cumulative through the course of the school year, unless they have what's called a manifestation hearing. Okay. So when your child gets to that 10th day, whether it be because there's a bunch of short-term suspensions or whether it be because there was one longer suspension that is going to be in excess of 10 days, they're entitled to a manifestation meeting where there's going to be a discussion whether or not that conduct was a manifestation of their disability. Just going back to what Stephanie said way back at the beginning of this presentation about those soft suspensions, taking children home without going through that suspension process. Well, I know that people do that and they do it for reasons, some altruistic reasons in terms of the not wanting students to go through the disciplinary process. Stephanie's right. There's a potential where you can lose those days in this count. And I always advise my clients, I ask them, have you been, has the kid been sent home early because they've been dysregulated or something like that? And if I get an answer yes, I will tack on those days to that 10-day count. Sometimes, people don't keep track of those days though. And so I think it's important that, you keep in mind what Stephanie said and indicated about those days. Okay. The manifestation meeting is going to be, need to occur before there's any disciplinary change in placement. And a disciplinary change in placement would be a placement that takes the child out of their agreed upon program that's on their IEP for more than 10 days, which is why that 10-day trigger is there. Okay. So the manifestation team meeting is really where that decision is going to be made as to whether or not the child's conduct is a manifestation of their disability. The manifestation team is comprised of pertinent members of the CSE, typically the chair, a school psychologist, a special education teacher, and potentially the building principal or whoever suspended the student to talk about the conduct, and the parent. Those individuals are going to look at two things. One, whether or not the IEP or the 504 plan has been followed. And two, whether or not the conduct in question was caused by or was a direct result of the district's failure to implement the IEP, or whether or not the conduct is a manifestation of their disability. And what that means is there's going to be a discussion. There's going to be a discussion. Okay, your son, your daughter got into a fight in the bathroom. Their IEP says they are classified because they have dyslexia. Is there a connection between the dyslexia and the fight in the bathroom? Okay. Without a lot of other details, I'm going to say no. Okay. But if you've got a child who has an IEP that has them classified OHI for, conduct disorder issues or emotionally has an emotional disability and they get into that fight, there's a distinct possibility that there is that connection then. And the team is going to have a discussion about whether or not there should be some sort of penalty or some sort of dispensation from the penalty because of the child's disability. If the decision is that it's not a manifestation of the student's disability, the student can be suspended into the same extent as their neurotypical peers. So they can be suspended out of school for the additional time, but their program and services on their IEP need to be provided during the suspension period. If there is a manifestation, though, the student is supposed to return to school immediately unless there's a basis for putting the child in what's called an interim alternative educational setting. Interim alternative educational settings can only be done if the student conduct rises to a specific level. So let's first talk about what an interim alternative educational setting it is. Basically, it is taking the child out of school or out of their agreed upon program and being placed into another program without the consent of the parent for a maximum of 45 days. And this can only happen if the child's behavior involved serious bodily injury, weapons, or illegal drugs or controlled substances. So just a fight in the bathroom that resulting in someone having a black eye is not what we're talking about with serious bodily injury. We're talking about something more significant than that. Obviously, having a weapon or having drugs or in school may result in this. If there is an IAES that is ordered, the CSE would determine which interim alternative educational placement the child will be sent to, and the parents have due process rights. So I think given the time, I'm going to just kind of jump to the end of my portion of this program. I'm going to get back to Stephanie when we're going to talk a little bit about those alternatives to discipline, because I think that's really what the most important thing is. I just want to stress as we go into this part of the discussion, as I said, this is a very regulated area with regards to the commissioner's regulations and the education law. There are a lot of things school districts would like to do other than to have a student miss days of school with regards to penalties for conduct. However, the statute has very prescribed penalties that can be ordered. There are a lot of times when a school district would love to say, okay, let's have this kid do community service, or let's have this kid get counseling. Unless a parent says, yes, I'm fine with that, we can't order that. So if a parent says, nope, my kid didn't do it, I'm not going to agree for them to do community service or agree to have them counseled. They're just fine. School district's hands are tied to a certain extent with regards to, okay, we found the child guilty of the conduct. The penalties are, time served or an additional time out of school. So when we get into this next section, I think it's really important to keep that in mind. Stephanie, you're on mute.
Go.
Okay, there you go.
Okay, so that was a terrific explanation in plain language of a very technical statutes, regulations with thousands of commissioners' decisions on each aspect of it. I would just like to say one or two words about two things that Stephanie said. One thing is the informal conference is a time to try to reconcile what happened, to try to tell the student, your student's perspective, as opposed to what, it's not a time to go in there and get all accusatory and talk about things that happened 25 years ago, and that will not help. We love to go to informal conferences. We don't go as attorneys, but the families, so that they can feel that they have been heard. And sometimes they can persuade the principal that it was a mistake. They can show it wasn't this kid. My kid was in the orthodontist. Here's the letter, things like that. But it is not a place to air grievances. And I really recommend that parents don't do that. The second point that I want to make is with regard to the MDR. Since students can only be classified with one classification in the state of New York, there are many children who may be classified learning disabled because of their inability or struggles or challenges in reading, however, have a lot of other disabilities at the same time. They could be learning disabled and have ADHD. They could be learning disabled and have an emotional challenge. So when we go to the MDRs, and that's even more than the suspension hearing, that is such a legally and technical meeting that we really strongly recommend that parents go with attorneys, because you can bring in documents like an evaluation, a psychiatric, the therapist, to show that the behavior that was the result of this incident really is truly part of this child's disability. So sometimes schools or people running the meeting will say, well, the kid is, LD. It's not that, but there might be on the front page of the IEP, a kid elopes, or whatever. So I think that's really important to understand the whole child at those meetings and to present the whole child. School district presents the information they have. You might not have shared that information even with the school. So that I think is very important, because that can
Yeah,
really help a kid.
I did not mean to imply that a kid
No,
was
no, no. I'm not saying you did, but it
yeah, no,
happens all
but
the
yes, you're
time. Yeah.
absolutely right.
Yeah.
Yeah.
No, no. I don't think you did it all, but I just think that parents don't understand the scope of that hearing or that meeting. Okay, so we get calls every day. My kid has an IEP, can't be suspended. And as Stephanie aptly explained, that's not true. There's just another level of protection. So I don't want to think because a student has an IEP that a district cannot suspend them. Nothing to do with that. They have that right. Um, so I think this is what people really want to talk about here. And this is what I really want to talk about. And that's, how do you prevent this to begin with? How do you not let it rise to that level? Sometimes a functional behavior assessment will target or trigger a particular behavior during a particular time of day or in a particular class, or something that would really dysregulate a student or a child. And that can be assessed by having a functional behavior assessment and having a behavior intervention plan. Um, Very often schools will offer counseling to children who are struggling with social emotional challenges or social emotional learning or social skills. And sometimes parents don't want that because they don't want the school in the child's misses. But there again, that's an opportunity for everybody to work together to try to help the child. And I think that the collaboration, before the disciplinary action happens is key. The teachers, the therapists, the specialists, the outside providers, the school people, that's really how you would do that. And you would request a review, either a program review or even maybe a team meeting that everybody could put their heads together to figure out. And it could be so many different things. The kids' blood sugar could drop and then they get irritable. Maybe they need a snack. Maybe that should be put into place. I mean, there's so many things that could be done internally before it reaches the level of suspension. And of course, the early intervention is so critical because students with disabilities, the data has been the same for years, are disproportionately suspended because if they're in general education schools, people might not understand that disability. So I also wanted to say, I spoke about the stipulations, and in the very things that Stephanie was explaining that cannot be ordered at a hearing can very easily be put into a stipulation, like counseling, like community service, like breaks, all kinds of different things that would really help a student. So those stipulations can be very valuable to really put something in place. They could say, let's have an emergency CSC meeting and talk about this child's placement. And if the child gets placed in a different program, he may or may not. There's so many creative lawyering things to be done and collaboration from all the community partners that you can do in a stipulation that you cannot do in a hearing. And this is something that I really want to stress to parents. Superintendent's hearings are not the forum to grieve about something that you don't like that happened in your child's school. It's not the appropriate venue. It's not a CSE meeting. It's not where you should be talking about um, anything else other than what happened on that day pursuant to those allegations. And if this child is found that he did commit those allegations, whether or not there's going to be a penalty. It's not to talk about, I've asked this, I've done this. It doesn't matter. And very often, when parents feel that they should be heard, and I think all people should be heard, um, that's not the place to talk about that. It's not that they shouldn't be heard. It's not the place. And parents say they want to go in and tell their story, but it's not really their story. It's what happened with this child. And I can't emphasize that enough because it's sometimes, I wanted my kid out of the school. Well, that's not the place to get the kid out of the school. So it sometimes really puts a very negative spin on the relationship between the school and the parent and the student. And that's really not to the benefit of anybody. So positive outcomes for students. Schools are in the business of educating children. Everybody's on this page. I don't think there's anything on this slide that an educator, a principal, a therapist, a parent, or a student wouldn't agree with. We want our kids to be in school and graduate, develop the social skills to have positive relationships, expand career options, gain the skills they need to be in a workforce, participate in civic and community activities, and engage in all healthy lifestyle behaviors. So thinking of that as the context and not all of the upsetness and anger is really how we like to frame it. And there's a tremendous amount of restorative justice practices that can be put into place to really try to help the student, be able to be in school, whether it's a risk assessment, whether it's counseling and anger management, community service to really teach the student, you know, that what he or she did might not have been the right choice, and this is a better choice. Mentoring relationships, restitution, paying for something that they broke, or maybe it wasn't intentional, but sometimes stuff breaks, you got to fix it, social skills groups. So there's a whole plethora of things that mostly are in the control of the school. Some of them aren't, that if the parent will agree and the student will participate. Now, the school district has no control over that. So that's why it has to be a collaboration amongst all of the stakeholders. And these are just some basic advocacy tips that we like to tell all parents. And I think many of them you may know, or many of them you cannot be surprised how many times someone say, I don't have that paper. I'm like, what do you mean you don't have that paper? I mean, keep copies of all the letters and the documents. Think about the timeline. It might feel to you like it's forever, but it might have only been a week. Um, know what your rights are. Request written communication so that you can go back and think about it and you can respond appropriately, not in the heat of the moment, not yelling and screaming, collaborate with schools and ask questions. Why is this happening? How can we solve this problem? Prepare for meetings by reviewing the documents, but you got to have the documents to review, so keep the documents. Inquire about alternatives to suspension. I really don't want my kid out of school. How can we work this out? Invite support when you do attend a hearing or you do attend an MDR. Maybe you want to consider bringing a therapist, an advocate, or an attorney to help you through this process, since it is a complicated and upsetting process. So those would be my tips. And this is really my final slide. And when there is collaboration amongst all the stakeholders, the students, the families, the school administrators, the educators, the community partners, we can't leave them out because they're key to some of the successes we see, collaborate, there's so much benefit. They will encourage compliance with the code of conduct, protecting the rights of students who are disabled, support that free and appropriate access to school, promoting positive school climate, not only for you, but for all the children, all the employees of the school, improving academic outcomes. If you're missing school, you're not learning. and building trust and shared responsibility, because that's what a school community should be. That's what we aspire to. So I thank you very much for listening.
I just want to just jump in here with
Please,
just two
please.
things. The first is I want to echo what Stephanie has said, but these hearings, both the manifestation meetings and the superintendent hearing, are really about your child and their conduct. There may be legitimate complaints that you have with regards to the way in which your child has been treated, and there should be an avenue for you to express that. I would suggest, setting up a separate meeting with a building principal, a central office administrator. But if you do it, as Stephanie said, at that point in time, you kind of lose focus on what's really important, which is dealing with the issues relating to your child. There's also, I think, a tendency to want to compare your child to other students in terms of the severity of the penalty or how they're being treated and the like, and you will hear over and over again from the school, we can't tell you those things. And they really can't. Just like we would not want to disclose information about your child's disability or your child's disciplinary records, we're not going to do that with regards to other students. But a lot of times there are other things going on behind the scenes that you don't know of. So don't come in assuming that your child's being targeted because student X over here didn't get in trouble and student Y did. Well, there may be reasons why student X didn't get in trouble, or student X did get in trouble, but we're dealing with it in a different way. The other thing I really want to stress is that school districts, at least the school districts I represent, and I think many of them across the region who my colleagues represent, really do want an alternative to out of school suspensions. And the state education department is moving in that direction too. The Board of Regents has put out a lot of white papers on reducing disparities in and reforming school discipline in New York State. They are asking for school districts to think about alternatives to address, student conduct that does not result in punitive penalties, as opposed to, trying to get students' conduct to change through, as we put it, restorative practices. That is something that I think most school administrators will embrace. The problem is, again, we need buy-in from everyone. We need buy-in from the staff. We need buy-in from the Board of Education. We need buy-in from parents. I can't tell you how many times I hear from a superintendent, okay, this kid caused a major fight and I've got parents banging on my door saying they want this kid thrown out of school, and if the community is all riled up that there is a problem in the school district, and that what needs to happen is that this student who's being targeted as the villain gets a long-term suspension. There's going to be pressure to act by the administration to kind of quell that. So it's really important that the community and the administrators and the parents of the student involved and the students who are victims understand that if what we're trying to do is teach kids that there's a different way to behave, and we don't want to teach it in a way that is punitive, then we've got to we either have to change the law or reduce the pressure on the people who have to make these very difficult decisions. And the best thing that you as parents of students can do is when when it's not your student who is the subject of this, but you're the student, you're the parent on the sidelines watching another kid get in trouble, try and, understand the pressure that, that family is going through and the school district is going through and trying to address it. And I think B, also, as Stephanie has, I think, aptly said, come in with some ideas for how to address this that may allow your child to get back to school earlier by showing, a commitment to doing the right thing. Whether, if your kid gets caught vaping for the fifth time, maybe it makes sense to come in and say, look, instead of a suspension, I signed him up for a drug cessation program. Here's the enrollment, and he's seeing this therapist every day. Can we just get him back to school so that, this doesn't happen again? If that, I can't guarantee anything, but that's going to go a long way to having a administrator say, you know what? Let's get this kid back to school and we'll deal with it that way, as opposed to you coming in and saying, my kid doesn't use drugs. They wouldn't do this. It was somebody else's vape. It just, the more defensive you are, now, obviously, I get it. If the kid is being railroaded and he really didn't do it, you want to get that across. But if the child did do it and you're trying to get a lesser penalty, the way to go about doing that is to be collaborative as opposed to be aggressive with regards to your defense, because that's not going to allow the opportunity to be more creative with regards to what we can do to address the conduct.
And I couldn't agree more with that, that working together with the school is the right approach. And there are odd, rare circumstances where things do happen, but for the most part, schools want kids in them and parents want their kids to go to school. And we want it to be done in an appropriate way. And sometimes it's hard for parents to accept some of the things. And we understand that, and that's pretty clear. So I do strongly believe in restorative justice. I don't think kids benefit from sitting home. I know that the learning is not the same. The very thing the kid needs is the FBA, and they can't do it if the kid's not in school. So I'm happy to always answer any questions. Student advocacy is a resource for anybody in Westchester and Putnam counties. And I look forward to continuing to do this work. And there is and has been a solutions, not suspension bill in the state Senate for a very long time. So that's the kind of advocacy parents can appropriately do if they want to see changes in the law.
Mhm.
So,
Great.
so thank you, everybody. Any questions? Feel free or no?
We had a question in the chat
Oh, I'm sorry, I
about
didn't see.
the
Yeah.
the stipulations you were talking about,
Mhm.
whether, at what point I guess a lawyer needs to or you would want a lawyer to get involved in that process.
I can tell you from the school district perspective that they do it differently in different districts. So
Mhm.
some districts, I do them routinely. Some districts I've done one, and then administrators and parents use that as a template. And when they're together, they do, they put it together. However it's done, the parent does have a say in what goes into it and should absolutely review it before it's signed. And whenever I draft one, I won't negotiate, quote unquote, the terms of it. If the parent doesn't have an attorney on the other side, I would just draft it for the school district and let the administrators and the parents then negotiate the terms thereafter. So it is something that is a formal document. So at some point, I'm sure a lawyer's hand was on it, but it may have been a lawyer's hand on it 2 years ago, and this is just a document that keeps getting revised at the district level.
And sometimes parents who are not represented by attorneys, because all school districts are, they create behavior contracts, or there's other words that they use instead of the term stipulation, which usually refers to a legal document. But if it's a behavior contract, you're still agreeing to do or not do something, and it's a serious document, and you should take it seriously. Sometimes, so I of course recommend having an attorney review it. But I do want to say one thing. Parents should pay very close attention to the notices, attend the informal conference if they feel it's appropriate, and also to the timelines. Parents go to these hearings, they're not clear on what they're for. The kid will be out of school, and then they call here really upset. But once it's not the dress rehearsal. This is the show. You gotta be, we gotta be in it to help. And parents will also feel like, well, I'll go myself. And if I don't like it, I'll appeal it. Well, student advocacy won't appeal matters that we're not involved in because we don't know what happens, you know? So that's something to really take seriously if you get that notice and pay attention to it. That's what we would recommend.
Yeah, and I do, just to that point, do want to say that 3214, the superintendent hearing determinations are appealable to the Commissioner of Education, who will review both for whether or not the school district met its burden of proof in demonstrating guilt or innocence, or will review the penalty to determine whether or not it was it wasn't proportional to the conduct. So the commissioner has been reducing penalties when she has felt that they've been heavy-handed in recent 2 or 3 years.
But that's an even more serious legal process
Yeah,
that requires written documentation. There's a very strict timeline, service requirements. So it takes a lot of. I would highly I would support any parent that wants to do it on their own. I say that's my hat's off to you, but it's not typical that that would be successful. Any other questions?
okay.
Okay. It was a
Thank you so
pleasure.
much.
Thank you so much, everybody. Thank you for the invitation, and I wish everybody a happy holiday season. Good night.
Thank you so much to Stephanie Roback and Stephanie Schambutman. This has been really illuminating. I especially love how you closed it out, right? About showing grace, right? Not just to our kids, but to the other kids who've gotten into trouble because
Mm-hmm.
any day could be our kids. So we want to always be thinking about that and how we can do it another way and collaborate, collaborate, collaborate. So
Absolutely.
thank you both so much for doing this evening for us, and thank you for all who have attended. And I will follow Stephanie by saying, have a wonderful holiday, everyone.
Happy holidays, everyone.
Bye, everybody. Take care. Bye-bye.
I think this is going.